We're talking to lawyers, and that means we're being hosted all week at O'Brien and Levine Court Reporting Solutions. And this means also that this is Radio Entrepreneurs. And the third component means that I'm with Mark Z from Mark Z Legal Staffing. Hi, Mark.
Jeff, great to be with you and this legal space, and speaking to some of the top attorneys in Boston is like the playoffs and World Series combined.
Great. Thanks, Mark. And my name, again, is Jeffrey Davis. I am the host of Radio Entrepreneurs and also the chairman and founder of Mage LLC, management consulting firm. And if you want to send me a message and be on Radio Entrepreneurs or know people to be on Radio Entrepreneurs, just contact me on my LinkedIn. Glad to talk to you. Glad to help out. Our next guest, watch this, Mark. I'm going to get it just the way you want me to. Pat Clendenen of Davis Malm Augustine, right?
Yes.
I got it all right?
Yes.
I'm
Thank
done.
you so much for having me today.
Well, Pat,
Thank you for coming on.
You have an interesting area that we love talking about. You're a partner, litigation and risk management development in the area of cyber liability. And I guess right now, especially after the elections, this whole tweeting, WikiLeaks, because the WikiLeaks guy had a bias. He didn't like Hillary, and that's okay. I'm not saying he shouldn't dislike Hillary, but, he had a bias, and it worked. He influenced the whole election, and there were a lot of leaks going on. So you seem to be right in the core of a very important part of the legal world today.
Right, and it's interesting because I've been practicing in Boston for 23 years, and to see the evolution from paper and fax to email and now text, and that's both managing our own information within a law firm, but also working with clients and managing litigation. So this has really become a national issue in so many different ways. And one of the significant ways that it's affected trial lawyers is in managing electronic discovery. And we all know in practicing in litigation that discovery is the most expensive part of the process, taking depositions, and you're supposed to disclose information so that's a full, fair, and cost-effective process. But with the explosion of information, from handhelds to data in different parts of a client's database, it's become difficult to manage. But there are some good signs that are coming down the road. And the first one is that the technology is caught up. So there's technology-assisted review. There are fabulous providers that can collect and cull and deduplicate data so that in producing information in litigation, it's progressively getting less and less expensive. And honestly, from my own experience, starting out as a young associate, it's a lot nicer to review documents online than thumbing through boxes and putting sticky notes on them. So there are some benefits to it. It's still something that, the process, the whole judicial system and the lawyers are working on.
What are the principal type cases, though, when we talk about cyber liability that you're working on? Is it, like as Jeffrey said, people where reputation is concerned, leaking private information, and then obviously when you look at what's going on with the Targets, the Home Depots of the world, and continually happens, do you represent a lot of the companies that are dealing with these issues?
Well, I work with my partners both on risk management and also when litigation occurs. So
Right.
the principal vehicle for this kind of litigation is class actions.
Right.
And one of the interesting developments in that area is that there's been a lot of dispute about whether a class can be certified when personally identifiable information or personal health information is leaked for one reason or another, because oftentimes the class representative can't show a specific harm that is
right.
So there's this whole standing argument.
Correct.
And there have been a couple cases that have come out recently out of the Sixth Circuit and the Seventh Circuit that have indicated that, yes, you have to show harm or an objectively reasonable risk or threat of harm.
Right.
And so for companies, what that means is if you get a breach and the data is not remediated quickly, then it's more likely that you're going to have a class action because the standing, they don't have to show specifically that Jeffrey Davis's identity was stolen and there's somebody in Beverly Hills charging your credit card to the tune of $5,000 a day. So that's not necessarily something you need to show in the class context anymore. So, and this really applies to all sizes of businesses, and it applies to law firms because we have clients that are auditing us. We're auditing our vendors. So I think for the listeners out there, it's important for people to understand that when you're entrusted with confidential information, whether you're a law firm or another business, that you have to do your best to maintain its confidentiality.